They have neither been pleaded nor argued.
If there are any rules or regulations, then registry must know it. And if they are not, they cannot frame it within 2
So
weeks.
to that extent, we would like to file an additional
So
reply.
you file additional reply
Yes.
by Monday.
Monday would be
This matter will be taken up on Tuesday.
because not tomorrow is a holiday. Not
ठीक है, तो रजिस्ट्री सैटरडे को काम कर रही है, रजिस्ट्री को बोलिए जब आप बनाएंगे,
रजिस्ट्री
उनके लिए कोई हॉलिडे नहीं है।
रजिस्ट्री कहाँ ही बनाती है, तो आपसे
ठीक है, ट्यूसडे को रखेंगे, मंडे तक जवाब फाइल कर दीजिए, जो फाइल करना है। अरे अगर आप नहीं है तो उसको एडजस्ट कर लेंगे। आपको तो कल ही बोल दिया था, खालिद साहब ने बोला कि 30 को रख लीजिएगा। हम
30-31 सब बाहर, बस 2 दिन बाहर।
जेन्युइन डिफिकल्टी
तो 2 फरवरी को रख लेते हैं, 2 फरवरी को रख देते हैं,
क्योंकि ये एक दिन पहले मिल जाएगा तो वी कैन गो
थ्रू। हाँ 2 फरवरी को रख देते हैं।
फ्राइडे आज बच्चे था ना, 2 को फ्राइडे है ना, नॉट could it be on 5th notes on
चलिए 5th को,
because there is genuine difficulty.
If it is there, they can produce it within no time. If it is not there, they will not be able to manufacture it.
Lord, this issue not has cropped up for the first time, Lord. Otherwise,
this is the issue which should have cropped up when you were preparing the reply.
Not if they had raised it, not we confine our reply.
It is not that. Whenever you prepare a reply, you are required to pose a question that may crop up at any point of time. So the issue is when there is a judgment of Akhil Bharatiya Ubhokta Parishad, and after reading that judgment, the only issue which crops up is that what are the limits on the authority of the Honorable Chief Justice to allocate a place to anybody, be it an association or somebody else.
It is all not subject to
चलिए सुनेंगे आपको, इसलिए आपको हमने क्वेश्चन पूछ के आपको समय दे रहे हैं ना। श्री सतीश वर्मा, ये पहले वाले में लिखिएगा 5193 में, श्री सतीश वर्मा लर्नेड काउंसिल फॉर द पिटिशनर, श्री B.N. Mishra, learned counsel for the High Court. Shri Mishra prays for some time to answer query of this court as was raised yesterday in regard to the extent of authority vested in the Chief Justice and whether it is supported with any rules, regulations or administrative orders. Next, on his request, it is directed that let affidavit of the Registrar General be filed on or before 2nd February 2024 with an advance copy to the opposite party. List on 5 February 2024 under the same head. Chali 1.1. 1.1, who is going to address? पांच की जगह इसको 6 फरवरी करते हैं, अगर आपको इनकन्वीनियंट नहीं। कहाँ है मिस्टर मिश्रा? 6 फरवरी करते हैं, क्योंकि 5 को क्या होता है, वो डायरेक्शन मैटर अगर बहुत लंबी लिस्ट रहती है मंडे की।
सर मुझे कोई इतराज नहीं।
6 फरवरी कर दीजिए। आपको कोई इतराज तो नहीं? 6 फरवरी
साथ ही कर दे सब।
क्या? नहीं, आप तो शुरू करें, तो भाई एक सवाल का जवाब देना है। इसमें लगाइएगा, 1 में लगाइएगा।
May it please my lords, WP 18637 of 2015.
Yes. जी
Well, this is essentially a petition that was filed wherein despite a policy decision by the state government,
जी
the High Court Advocates Bar Association and Madhya Pradesh High Court Bar Association, both are petitioners here. We're being forced, my lord, to make the payment of the electricity connection that has been respectively given to both the associations.
Where is the policy decision?
May I just, my lord, before that, take my lords to a decision of this honorable court. Which my lords will find in our rejoinder, my lord, as RJ1. Page number 12.
जी
Vinod Kumar Bharadwaj versus State of MP.
जी
A division bench decision, my lord, the Gwalior bench.
जी This is probably based on a concession by the council. पढ़िएगा इसको जरा. If my memory serves me right, this was based on a concession.
देखते हैं सर आगे, मेरे हिसाब से तो concession नहीं.
पढ़िएगा चलिए.
The public interest litigation has been filed by senior advocate in representative capacity for issuance of a direction to the state to the effect that electricity charges of electricity consumed in the bar association rooms or rooms provided by the court to the members of the bar association be paid by the state government. The petitioner has pleaded that he is a senior advocate practicing in the district court and high court since a long time. More than one bar rooms have been provided by the courts for the purpose of sitting of bar members during the court hours. The advocates used to sit in the bar rooms, they consult with their clients in the bar rooms, and they also used to read and prepare their briefs in bar rooms when they are not required to appear before the court. It is further submitted that it is a part and parcel of the process of administration of justice, and the government has a responsibility to bear expenses for the administration of justice. However, the electricity charges of the electricity consumed in the bar room have been paid by the bar association, and it has to be paid by the government. It is further submitted that that the Honorable Supreme Court is paying all the electricity charges of bar association rooms. Even the Supreme Court is providing other facilities also. In other states like Rajasthan, the government used to pay electricity charges for electricity consumed in the bar rooms. It is further pleaded that for the purpose of effective administration of justice, the government has to provide expenditure for well-equipped bar rooms, including library and electricity charges. The state government in its return denied the claim of the petitioner. It has pleaded in the return that each and every bar association has affiliation with the State Bar Council of Madhya Pradesh, which is a statutory body. The Bar Association also receives contribution from its members as monthly fees. The State Bar Council also receives application fee of rupees 1,000, registration fees of 11,200 from each advocate at the time of registration. The State Bar Council has sufficient funds to pay the electricity charges of bar rooms of the court. It is further pleaded that the advocates are in a profession and for their benefit, bar rooms have been provided. And for the purpose of maintenance of bar rooms, it is the duty of the advocates to pay monthly contribution and maintain the same. In the return, state has opposed the plea of the petitioner. However, during course of the argument, learned Additional Advocate General has produced certain papers to the effect that the process of decision making is going on in regard to payment of electricity bills of bar rooms in the court premises by the government. Learned Additional Advocate General informed the court that a Vakil Panchayat was held on 12/8/2012 at the residence of Honorable the Chief Minister. And in the aforesaid Panchayat, Honorable the Chief Minister made a declaration that the state government shall provide electricity charges of the bar rooms, and for the purpose of implementation of the declaration, a committee of Honorable the Chief Minister, Chief Secretary, Advocate General, and Secretary of Law has been constituted, and the matter is under active consideration of government. Learned Additional Advocate General further produced a letter dated 29/9/2012, wherein by the Secretary Law and Legislative State of MP to the Registrar General, which is mentioned that how much amount shall be required for the purpose of payment of electricity charges of sitting places of litigants in the court premises. In this letter, the expenses in regard to providing tube lights and fans in the court premises is also included. The registrar establishment, by letter dated 3/1/2013, has informed the government in regard to amount which would be required for payment of electricity charges In pursuant to the letter of Law Secretary, Learned Additional Advocate General has submitted that on the basis of aforesaid correspondences, a decision would be taken within a certain period and the matter is under active consideration before the government. Learned Senior Counsel dash petitioner in person himself has contended that the government has made number of declarations, but those have not been followed. It is further submitted that the profession of the advocates is part and parcel of administration of justice, and the advocates are the officers of the court. Hence, it is obligatory and mandatory for the state to provide free electricity to the bar rooms situate in the court premises, and it is necessary to decide the aforesaid rights of the advocates, that is, bar association, in principle, and it could not be left on the mercy of the state government. It is well settled principle of law from century that the advocates are officers of the court. The Honorable Supreme Court in Lalit Mohan Das versus Advocate General Luisa AR 57 Supreme Court 250 has held as under. A member of the bar undoubtedly owes a duty to his client and must place before the court all that can fairly and reasonable be submitted on behalf of his client. He may even submit that a particular order is not correct and may ask for a review of that order. At the same time, a member of the bar is an officer of the court and owes a duty to the court in which he is appearing. He must uphold the dignity and decorum of the court and must not do anything to bring the court itself into disrepute. The Honorable Supreme Court in the case of O.P. Sharma and others versus High Court of Punjab and Haryana 2011 6 SCC 86 has held as under in regard to right and status of lawyers and duty of the advocates. The role and status of lawyers at the beginning of sovereign and democratic India is accounted as extremely vital in deciding that the nation's administration was to be governed by the rule of law. They were considered intellectuals amongst the elites in the
जो
country.
relevant है वो बताइए, पूरा मत पढ़िए यहाँ पर.
Sir, थोड़ा सा तो
जो relevant नहीं please, जो relevant है वो पढ़िए. जो relevant है, क्या कहा उन्होंने, किस प्रिंसिपल के ऊपर यू आर एंटाइटल्ड टू फ्री इलेक्ट्रिसिटी, इतना बता दीजिए.
सर ये
रेशियो ऑफ लॉ क्या है, प्रिंसिपल क्या है, व्हाट इज द प्रिंसिपल कॉल्ड आउट ऑफ दिस जजमेंट.
तो वो नीचे से ही है, उसी लाइन में देखेंगे आप नीचे.
किस पैराग्राफ में?
उसी जिस पेज में मैं पढ़ रहा था आपको, उसी के कंटिन्यूएशन में आखिरी जो लाइन है, जो फाइंडिंग है कोर्ट की.
हाँ बताइए क्या फाइंडिंग है.
It is clearly mentioned in the aforesaid judgment that the lawyers are the officers of the court in the administration of justice. Now this is finding number 1.
नहीं, ये तो लिखा दैट द लीगल प्रोफेशन हैज एन इफेक्टिव एंड डायरेक्ट एसोसिएशन. पैरा नंबर 9 के ऊपर जो है, यहीं पढ़ रहे थे ना आप?
नहीं सर,
पैरा 7 कंप्लीट हो गया.
पेज 15 पे है.
Lawyers are the officers of the court in the administration of justice. जी
जी, it is clearly mentioned, ये फाइंडिंग है जो पहले.
जी
ये मिला नहीं सर?
हाँ मिल गया, चलिए.
लास्ट की 2 लाइन है.
हाँ जी जी.
It is clearly mentioned that the lawyers are the officers of the court in the administration of justice. Para 8. The Honorable Supreme Court in the case of Supreme Court of Bar Association others versus B.D. Kaushik.
उन्होंने B.D. कौशिक में तो ये कहा कि वो सुप्रीम कोर्ट दे रहा है फ्री बिजली. It is not in dispute that there are about 10,000 members. यही है ना ये?
जी.
हाँ जी. फिर पैरा 9 के नीचे कहा, it is clear from the aforesaid judgment that the legal profession has an effective and direct role, direct association with the administration of justice.
This is finding number 2.
हाँ जी.
The Honorable Single Judge of Karnataka High Court in the case of Advocates Association Bangalore versus Chief Minister Government of Karnataka Bangalore and others has held as under in regard to duties discharged by the advocates and obligation of the government to provide facilities to Bar Association. The nature of duties discharged by an advocate is in the nature of public duty. The accommodation oblique building for an association must be construed and treated as part and parcel of the building of the court or court complex. And it cannot be treated differently from the building required for housing of courts.
इसमें स्टेट का रिप्लाई आ गया है. स्टेट हैज फाइल्ड इट्स रिप्लाई और नॉट? जी, स्टेट का रिप्लाई है ना इसमें? यस, ठीक है. यस, कंटिन्यू प्लीज.
There cannot be effective working of the judicial system or functioning of administration of justice in a democratic polity unless the lawyers and judges working the system as complementary for each other. They are 2 limbs of the system or can be compared to 2 wheels of a chariot of justice. The chariot of justice cannot move or achieve the desired object unless both the wheels work and function complementary to each other. Just as the need of highly competent, honest and devoted judiciary is a must for the protection of rule of law, competent, honest and devoted bar is also a must. Therefore, in a country like ours, where the majority of the advocates are not in a position to acquire necessary tools or facilities required by them for effective discharge of their professional duties, a duty is cast on the state to provide minimum facilities like building for an advocates association, minimum library, and other facilities to the advocates association. It cannot be disputed and the need of an independent and strong, efficient and honest judiciary for maintenance of rule of law and for the continued existence of democratic form of government which we have accepted. It also cannot be disputed that the source of recruitment, whether of higher judiciary or subordinate judiciary, is from the bar. In the aforesaid judgment, it is held that it is obligatory on the part of the government to provide free electricity to the Bar Association. This is observation of the division bench. Number 3. From the aforesaid quoted judgments of the Honorable Supreme Court and the High Court, it is well settled principle of law that the profession of an advocate is not mere a profession. The advocates are officers of the court. They have their duty towards their clients and also towards the court. And an efficient and intelligent bar is necessary for the effective administration of justice. If the bar does not have proper facilities in the court premises, then the administration of justice would be affected adversely, as observed by Honorable Supreme Court in the case of Supreme Court Bar Association and other Supra. The Supreme Court is providing 4 huge libraries, 3 canteens, 2 lounges, several rooms as consultation rooms, parking places, and free use of electricity supply to the members of the Supreme Court Bar Association. It's a common knowledge that the members of Supreme Court Bar Association have been earning much more than the members of High Court Bar Association or District Court Bar Association or Tehsil Court Bar Association. When they are being provided facilities of free electricity, then certainly the members who are working in the High Court, District Court and Tehsil courts are also eligible to get free electricity in the bar rooms officially provided in the court's premises. The state government cannot ignore this aspect of administration of justice to the effect that for providing facilities to the advocates in practicing so that they can effectively practice before the courts. During court working hours, the advocates have a facility to sit in the bar rooms, which is officially provided by the courts. In the aforesaid bar rooms, they used to sit when they are not required to appear in the court. They used to read the files and law books and also used to consult with their clients when it is held that the profession of the advocates is not merely a profession, but the advocates are officers of the court. Then certainly they are entitled to get some facilities. Consequently, it naturally follows the electricity charges of the electricity consumed in the bar rooms officially provided by the court shall be paid by the state government. It does not mean that state government has to provide air conditioning charges in bar rooms. It is obligatory on the part of government to bear electricity expenses of fans, tube lights and bulbs and also of coolers during summer session in the bar rooms of High Court, District Court and Tehsil Court officially provided by courts. We have made these observations in regard to district courts which are within the jurisdiction of this bench and also the bar rooms of the High Court of Gwalior bench, because this bench has jurisdiction to issue direction within the jurisdiction of Gwalior bench. We also appreciate the gesture of the government that it has itself taken an initiative in this regard. We hope that government shall take proper decision in this regard within a particular time. Consequently, this public interest litigation is allowed with the following. The government is responsible to pay the electricity charges of the electricity consumed by electricity appliances, that is bulbs, tube lights and fans, also coolers during summer season in the notified bar rooms of the district courts and other courts situated within the territorial jurisdiction of this bench. The government is also liable to pay electricity charges of electricity appliances of the notified bar rooms of the High Court of MP Gwalior bench. The government can verify the expenses or leave this and that is further the rights would be applicable to courts which are within the territory, because the issue was with regard to the Gwalior jurisdiction. So this is the principal decision I am relying on, my lord, for the proposition that this honorable court in its division bench, my lord, has come to the conclusion and has been pleased to hold that it is the responsibility of the government to provide for the electricity charges of the bar rooms, my lord, which are situated within the court campus. Now, this matter, my lord, was further taken up before the Honorable Supreme Court by the state of MP, because they apparently were of this opinion that it's only where the litigants or other Nyaya Mitra and all those schemes under which there's some kind of a place where a common man, a litigant can come and wait and can have water or some facilities. It's only those places they'll be providing, others they'll not be providing. However, my lord, may I just, at the cost of repetition, in the penultimate paragraph, the lordships have clearly held, my lord, in that division bench, if my lord may take a note thereof. Para 11, my lord, at page 18
Yes.
of the rejoinder. Consequently, third line, it naturally follows the electricity charges of the electricity consumed in the bar rooms by the court shall be paid by the state.
उसमें कहा है ना bulb, tube-light, fan and cooler during summer season, not the air conditioners.
But this at least valid is established and it's been held by a division bench of this court that we are entitled. So far as the entitlement and who's going to bear the expenses concerned. Now, Lord, against this, the state government, my lord, took the matter before the Honorable Supreme Court, which my lords will find in the memo of writ petition, page 17, annexure P1.
Just a minute.
This is petition for special leave to appeal, civil number 1440.
कहाँ लगा हुआ है ये?
Page 17,
And petition के साथ.
petition.
जी.
No, it's this probably, my lord, in the beginning was referring to that there was a consensus order. So it was probably in this context, my lord. Because when the matter went up, the state probably made up a statement on the basis whereof the SLP itself was disposed of, meaning thereby that the order passed by division bench, my lord, remains intact. I'll just read it, it's a small order. By letter dated 27/5/2013, the government of Madhya Pradesh Department of Law and Legislative Affairs communicated to the working secretary to Pradesh State as follows. In relation to announcement bearing number A2480 made by Honorable Chief Minister in the Adhivakta Panchayat for payment of electricity bills. In relation to the above mentioned subject, it is most respectfully submits.
नहीं पूरा छोड़िए मत.
जी.
Bill, electricity bills of the places used for the sitting of the clients in the court compound premises will be examined.
जी.
Made by the Honorable Chief Minister in the Adhivakta Panchayat.
जी.
The state government after examination has already allotted rupees इतना इतना to the Honorable High Court by department memo इतना इतना.
जी.
जी.
मैं पढ़ देता हूँ.
हाँ पढ़िए.
आप ही रोक रहे हैं मुझको पढ़ने से.
नहीं मैंने कहाँ रोका आपको.
आप कह रहे हैं लंबा मत पढ़िए पूरे, मैं तो सब पूरा पढ़ के आपको बता रहा हूँ. This is a very small order.
जो पढ़ रहे हैं उसको पूरा पढ़िए.
जी जी बिल्कुल.
जी.
पढ़ना तो मैं उसको भी चाह रहा था जो आपने नहीं पढ़ने दिया.
चलिए उसको वापस चलते हैं, पूरा पढ़िए.
वो चले अब क्या सब कॉन्टेक्स्ट से आपने बाहर कर दिया, मैंने साहब आपने जो बोला मैंने उसको मान के आगे चल गया.
थैंक यू.
In relation to the announcement bearing number A2480 made by Honorable Chief Minister in the Adhivakta Panchayat for payment of electricity bills, in relation to the above mentioned subject, it is most respectfully submitted that in furtherance of the announcement number so and so, that is the proposal pertaining to payment of electricity bills of the places used for sitting of the clients in the court compound oblique premises will be examined, made by the Honorable Chief Minister in the Adhivakta Panchayat. The state government after examination has already allotted rupees 65.59 to the Honorable High Court by department memo dated 7/5/2013. Learned senior counsel and counsel for the parties agree that special leave petition may be disposed of in terms of the above communication. The prayer made by the learned senior counsel and counsel for the parties is fair and reasonable. It is observed that the impugned order of the High Court is rendered unnecessary in view of the above communication. Sent by the state government to the working secretary, Madhya Pradesh State Bar Council. In our opinion, no further order needs to be passed in the special leave petition. It is disposed of accordingly.
जी.
So my submissions are twofold here.
जी.
The state in its wisdom, and it was fully aware of this fact, that they are only dealing with places where the advocate, where the general public will come and sit. And if we read that order, especially the paragraph that I pointed out, for bar rooms, at least barring AC, everything else was required to be paid. And even in summer, the cooling charges were required to be paid.
जी.
Now, when that was the essence of the order, and that was part of not only the reasoning of the order passed by a division bench of this honorable court, but also in its operative part where they enumerated 1, 2, 3, 4, 5, these are the directions against which when they have come in, why did they agree to this fact? And they themselves brought this on record before the Supreme Court that it's being actively under consideration, and the Chief Minister has said, hence no order is required.
I request you to read para 3 of the order of the Supreme
Yes,
Court.
yes. The prayer made by learned senior counsel and counsel for the parties is fair and reasonable.
आगे पढ़िए.
G. It is observed that the impugned order of the High Court is rendered unnecessary in view of the above communication sent by the state government to the working secretary, Madhya Pradesh State Bar Council.
By implication, the order of the High Court is stood nullified because it is Supreme Court is saying is rendered unnecessary.
In the light of what the councils have submitted.
हाँ.
Yes, in the like the said अब require नहीं है इनको,
ठीक.
but with great respect, my lord, the second submission, the second limb of my submission is,
जी.
it did not, my lord, simply by saying that in this SLP we may not test it. It's not necessary for us to test it in the SLP when the parties themselves are saying that the grievances sought to be met by the policy decision of the state government.
Right.
They nowhere, my lord, with great respect, have affects, my lord, the applicability and the standing of the order passed by the division bench of this honorable. The order remains.
Right.
So in these facts and circumstances, wherein a part of the state, especially within the jurisdiction of the Gwalior bench, therein, my lord, there already an order stands. Their lordships have withheld because it was dealing with the courts and other things which were within the territorial jurisdiction of the Gwalior bench. And there, my lord, we are seeking a parity and extension thereof. And, my lord, as this, the decision of the Honorable Supreme Court stands undisturbed, and the ratio of law, my lord, which has been decided by a division bench of this Honorable Court, stands, my lord, undisturbed. The state cannot now, my lord, take a different stand, behaving as if at Gwalior they are Mr. Hyde and at Jabalpur and Indore they are Dr. Jekyll. They cannot have a twin personality.
Right.
Now, my lord, may I most humbly further submit to my lord's commendation certain paragraphs of B.D. Kaushik.
दीजिएगा. 2000
11, volume 13, SCC 774.
774. बुलवाइए. अच्छा इसमें है क्या? बीडी कौशिक इसमें है नहीं. एक मिनट वेट करिएगा. बुक्स बुलवा. Are you going to refer to some other judgment also? तो लिस्ट दे दीजिए तो वो बुक आ जाएगी अभी.
Primarily B.D.
Okay.
B.D. Kaushik, ये तो लगा ही. In fact, B.D. Kaushik, my lord, can find probably we have enclosed that also.
ठीक है.
Along with rejoinder.
My brother has passed it on to me. लीजिएगा बताइएगा please. You are reading from where?
Rejoinder में देखेंगे सर.
हाँ ठीक है. आपने दे दिया है.
जी जी rejoinder.
है. जी बताइएगा please.
Para 28 पे देखेंगे.
Para 28 yes.
There is no manner of doubt that court annexed bar association constitute a separate class different from other lawyers' associations such as lawyers' forum, All India Advocates Association, etc., as they are always recognized by the court concerned. I just pause here for a moment, my lord. Recognized by the court concerned. Court annexed bar associations function as a part of the machinery for administration of justice. As is said often, the bench and bar are like two wheels of a chariot and one cannot function without the other. The court annexed bar associations start with the name of the court as part of the name of the bar association concerned. That is why we have a Supreme Court Bar Association, Tees Hazari District Court Bar Association, etc. The very nature of such a bar association necessarily means and implies that it is an association representing members regularly practicing in the court and responsible for proper conduct of its members in the court and for ensuring proper assistance to the court. In consideration thereof, the court provides space for office of the association, library, and all necessary facilities like chambers at concessional rates for members regularly practicing in the court, parking place and canteen, besides several other amenities. In the function organized in the Court Annex Bar Association, the judges participate and exchange views and ascertain the problems, if any, to solve them and vice versa. There is thus regular interaction between the members of the Bar Association and the judges. The regular practitioners are treated as officers of the court and are shown due consideration. Thereafter, my lord, I seek my lord's kind consideration to para 80 and 81. My lord, has it? Para 80.
Yes, please.
This court has considered the request made by the learned counsel appearing in the matter to give appropriate directions, guidance for effective implementation of one board principle initiated by the amended rule. It's a matter of common knowledge that this court has provided 4 huge libraries, 3 canteens, 2 lounges, several rooms to be used as consultation rooms, where learned advocates regularly practicing in this court can consult with their clients, arbitration rooms, advocates' chambers, huge parking places, free use of electricity supply, etc. to the members of Supreme Court Bar Association. It is not in dispute that there are about 10,000 members of SCBA at present, though the actual number of advocates petitioners who are regularly practicing in this court is not more than 2,500, out of which there are about 900 advocates on record. It is an accepted fact that on the eve of annual elections, because this was in the context of elections, my lord, I can skip at 81. 80, my lord, I said specifically where the lordships have dilated and held that free use of electricity supply. Now, just, my lord, pausing here for a moment, I take my lords to para 11 also.
जी.
Para 27, sir.
Not 11.
Not. रिजॉइंडर में पैरा 11 है जो आपके, अगर रिजॉइंडर से देख रहे हैं,
नहीं मैं तो
बुक से देख रहे हैं तो सर ये पैरा 27 होगा और उसमें 786 पेज नंबर.
जी बताइए प्लीज.
The Supreme Court Bar Association, as the name suggests, is a society primarily meant to promote the welfare of advocates generally practiced in the Supreme Court. The name, that is the Supreme Court Bar Association, was formally registered under the Societies Registration Act 1860 only on 25/8/1999. One of the prime objectives of SCBA is to establish and maintain adequate library for the use of the members and to provide other facilities and convenience to the members. Thus, the formation of SCBA is in the nature of aid to the Advocates Act 1961 and other relevant statutes, including Article 145 of the Constitution. Although not very germane for the instant purposes, but apparently, and as the stand of the respective parties go, probably I'll have to face this stiff opposition on the count that the benefit with regard to free electricity may be allowed to one association and disallowed to the other.
That you are apprehending from them.
Not apprehending. We have had a trial run before the other bench.
Okay.
A complete full run. It was reserved after hearing everybody, but for some reason it was reopened because their lordship thought all the 3 issues are so interconnected, they'll have to be heard to.
Okay.
It was heard completely. I'd argued, as I'm arguing before my lords, the other parties also argued. So I'm aware. We are mutually aware of each other's stand. So that was some sort of a thing was sought to be done. What I'm trying to submit here in my lord.
Just a minute for our information. That is the stand of the state government
No,
or the
not
electricity board.
Not the state government, the interveners, especially my eloquent friend who addressed my lords yesterday.
नहीं उनका इसमें to best of my understanding ज्यादा लोकस नहीं है. ये समझना चाहता हूँ आपने जो अभी इशू रेज किया that one of the bar may be allowed and another may be not allowed. Is this the stand of the state government
No,
also?
that's not the stand of.
What is the stand of the
Stand of the state government says that a bar association across the state have to fend for themselves and are required to pay
Okay.
their electricity.
Okay, right.
That's.
Chaliye.
So, my lord, I am at the cost of repetition most humbly submitting that in the Supreme Court Bar Association other versus BD Kaushik, that was, my lord, an SLP which arose directly from the order passed by a civil judge class 2, where some injunctory orders pertaining to the elections were taken by some members, namely BD Kaushik and others. Because the Supreme Court Bar Association introduced some kind of a rule in their regulations that any person who only those persons who are primarily practicing in the Supreme Court can vote. People who are coming from outside, people who are member at the other association, etc., they will not be able to vote. One bar, one vote, that concept. Because more than 15,000 people got enrolled in the Supreme Court Bar Association, it became virtually a nuisance in the sense that most of those people only came at the time of elections. They were called and they were doing it. So in that context, my lord,
That happens in almost all the associations.
in most of the associations, my lord, that's what we see. It's a number game in democracy, and people try to bring in the members. So that was sought to be curbed by the by the leadership at that point
Main
of time.
thrust of this judgment is that since bar associations are annexed to the court building,
Yes.
they are. That is the thrust of
Yes,
this
sir.
judgment.
And my lord, what I'm saying is there are finer aspects in para 28 itself. My lord, we kindly permit, let us read 28 once again, para 28.
Please, please.
Yeah. There is no manner of doubt that court-annexed bar associations constitute a separate class different from other lawyers' associations. It's a very important.
I have understood that.
Yes.
That's why I said that
Yes.
this is the crux of the matter
No,
as far as we are concerned.
Yes.
Our present case is concerned. BD Kaushik is to be read only in this context.
In this context. But as also there's a
Because we are not dealing with one vote, one bar,
Yes,
and all
we're
those
not.
things.
My lord, we are because in the context of my lords dealing in decision, आप लोग कई points raise होते हैं, my lords answer various points. इसके आगे देखें सर.
Okay.
Etc. As they are always recognized by the court concerned. So what is important here is well recognition by the court concerned.
Yes.
The court only, you will get these facilities only when the court recognizes it. You cannot just barge in and start taking out a facility. Court-annexed bar associations functions as part of the machinery for administration of justice. As is said often, the bench and bar are like two wheels of a chariot and one cannot function. But I had read this, I'll not further. It was only this particular initial paragraph
Yes.
wherein it said that it has to be a court-annexed, and secondly, naturally, it has to be recognized.
Recognized.
By the court.
Since it is court annexed, it is automatically recognized by
Recognized
the
by the
court.
So this is it. And thereafter, my lord, the lordships have clearly said, well, para 18 need not dilate, that these are various facilities we've granted. There's another very important aspect where reading para 27 is concerned, that Supreme Court Bar Association, which is probably the apex body of such associations in the country, itself is a registered society. Nowhere, my lord, I could find in this decision, was it that they had applied for or they want, or they are or are not recognized by the bar.
Are you moving to yesterday's issue? Or if you are addressing, then please reserve your argument for fifth.
ठीक है.
अभी तो we'll
जी.
concentrate on complexity.
तो मेरा submission ये है कि sir, so far as this cause is concerned, both the petitioners stand on the same platform. Both are petitioners in the same cause, but petitioner 1 and petitioner number 2. In the light of what has authoritatively been decided by a division bench of this honorable court, which, my lord, in my humble submission and understanding, despite the fact that in the light of what the state was to dilate, my lord, both the parties or the state which brought that information before the Honorable Supreme Court, all of them thought that now dealing with this issue has become unnecessary because they are going to deal with it without realizing that there's a fine point, that there's a wheel within the wheel, in as much as what the state probably wanted and how everybody misunderstood, even including them, was it is only for the places where the litigants come and say. Now, assuming that to be correct, good, bad, or indifferent, the decision of the division bench dealt specifically with the bar associations. Not only, it's one of the aspects or facets of the facility of bar association is that our clients can also come and consult with us. While the state wants, it's only that place where exclusively the clients are there. With the moment lawyer enters into that facility or that arena, probably it's pariah for the state government. Then they will not pay. This is what their stand is. Now, so far as my information goes, that the bar associations, especially the district bar associations all throughout the country, well, none of the bar associations, my lord, is charged with this probably. Where so is paid by the setup of the district court in the entire state of Madhya Pradesh. One. Now, secondly, well, so far as the High Court Advocates Bar Association, what we came into.
Please give me a minute.
Yeah.
Ji, please proceed.
Ji. Secondly, my lord, that petitioner number 2, the Madhya Pradesh High Court Bar Association, which has been functional since when the High Court came in here from Nagpur. It was part of this main building. It was where presently earlier the cause list used to be there. Now some other sections are there. Right from that date up till the point of time they shifted into the new building, they never paid any electricity bill. We neither charged any electricity bill nor we paid any electricity bill.
Petitioner number 2.
Yes.
Ji.
And thereafter, my lord, when this issue pertaining to whether we'll be paying as a bar association, is there a requirement for us, which is a court annexed or as within the building is here itself in the court campus provided to us by the court, and we being court annexed bar association, are we required to pay or not? And these issues started doing rounds, and they were dealt with, my lord, somewhere in 2012 by the then Chief Minister in that Adhivakta Panchayat, and all of us thought, my lord, that it's not to be done, because just before that 2 meters were installed in our premises by the electricity companies. So far as we are concerned, my lord, the petitioner number 1, when those facilities were given to us and we expanded those facilities, library and other thing, an electricity meter, we were advised by the electricity people to put electricity meter. At the same time, probably the electricity meter came to the down to the main bar association. But in the light of this 2012 declaration, prior there to, my lord, so far as number 1 is concerned, we were routinely paying our electricity bills.
Ji.
But with this 2012 declaration, when things became clear and we came to know of the decision.
Prior to 2012, you were paying your
bill. for certain years.
Petitioner number 1 was paying.
We were paying. We took the connection. In fact, everything started with that connection. Had we not taken that connection, probably we will not be standing here. We, in our right earnest, thought when we were provided this facility that we should interact
prior
with.
Prior to 2012, that is Adhivakta Parishad, Adhivakta Panchayat.
Adhivakta Panchayat. It's only during that period, my lord, so far as
petitioner number 1 was paying.
Petitioner number 1.
कैसे आप कैलकुलेट करते थे बिल के?
बिल मीटर लगा सर, तभी भी दोनों जगह
मीटर आप बोल रहे ना, मीटर नहीं लगता तो हमको यहाँ खड़े नहीं.
हमने अप्लाई नहीं करते तो मीटर नहीं लगता, तो हाई कोर्ट से कनेक्ट कर लेते उसको, जैसे पहले कनेक्टेड था, नीचे वाला बार कनेक्टेड था.
नहीं, मैं दूसरा सवाल पूछ
जी.
आपने ये कहा कि 2012 जब ये अधिवक्ता पंचायत हुई, उसके पहले आप अपने बिल्स पे करते थे.
जी.
आपने ये भी कहा कि मीटर लगा 2012 में.
नहीं, उससे पहले नहीं. अच्छा. हमने तो शुरुआत में जब 2008 वगैरह में जब पहले हमको मिला, तो जब नई फैसिलिटी हम लोगों को मिली, पहले तो ये छोटी जो कोर्ट रूम 20 के पास जो सीनियर काउंसिल्स का जो मिनी बार रूम है,
You were paying your bills.
हाँ जी, बिल्स दे रहे.
up to 2012.
12 तक दे रहे. 12 के बाद हम लोगों ने, so far petitioner one is concerned, हम लोगों ने looking to these orders passed and this litigation going on and big declaration made in favor of the legal community. We were very happy that Honorable Chief Minister is looking into these things and has come to our rescue, and we may not be required to pay the electricity bills. So in that, but so far as our respondent number 2 is concerned, they also from 2012 stopped paying after that.
Petitioner number 2.
Petitioner number 2.
You are petitioner number 1.
I am petitioner.
But you said that petitioner number 2 never paid from 1956.
They never paid. I'm saying when it was a part of this building itself, the main building itself, with the cause list subsequently came in, because when initially the Madhya Pradesh Bar Association, this High Court Advocate Bar High Court Bar Association was there when it came from Nagpur. It was in the main building. Courtroom number
नहीं
2.
नहीं वो ठीक है, थोड़ा सा फैक्ट्स क्लियर कर रहा
जी,
हूँ
जी.
मैं। इनिशियल टोन एंड टेनर से लगता है कि जो पिटिशनर नंबर 2 है उन्होंने 1956 से आज तक कभी भी बिल पे नहीं किया।
नहीं, नहीं.
आपने अपने इंसेप्शन से लेकर 2012 तक पे
जी,
किया। 2012 में जब अधिवक्ता पंचायत में घोषणा हुई उसके बाद से आपने बंद किया है।
जी, उसके
ये मैंने सही समझा है?
जी, बिल्कुल.
है
नंबर
यही
2
कह
ने
रहे
भी
हैं ना?
पेमेंट किया है,
है?
नंबर 2 ने भी स्टॉप पेमेंट किया इस पिटीशन के साथ में,
अरे एक सेकंड,
पहले किया है।
पहले किया है
हाँ,
तो वो
किया है।
मैं वही तो फैक्ट क्लियर कर
नहीं
रहा
नहीं, वो
हूँ।
किया है, इट्स नॉट ए करेक्ट फैक्ट।
कब तक
दे
किया है?
स्टॉप्ड पेइंग, वो समटाइम्स उसी समय का विवाद है,
कब से किया?
पहले दे वर पेइंग।
वो फैक्ट्स क्लियर नहीं.
अरे एक सेकंड, क्योंकि फैक्ट्स क्लियर हो जाए,
जी, जी.
गलत बात लिखे की कोई मतलब नहीं है।
जी, जी, जी.
तो 2012 के पहले दोनों एसोसिएशन दे रहे थे पेमेंट एंड 2012 से स्टॉप किया है।
जी.
क्या बोल रहे हैं वर्मा जी? क्या वो
वर्मा जी से मैं पूछ रहा हूँ कि हमको जो
मैंने जैसा रिकॉर्ड देखा कि नंबर पिटिशनर नंबर 2 कभी नहीं किया सर।
कभी
मैं
नहीं?
अभी कंफर्म करा
मतलब
देता हूँ।
वो वेरीफाई भी कर लेंगे।
हाँ, मैं
हाँ,
कंफर्म
तो
कर
उस
लेता हूँ।
फैक्ट को एक वेरीफाई कर
वेरीफाई
दीजिए, क्योंकि फैक्ट गलत नहीं होना चाहिए। फैक्ट गलत नहीं होना।
सर, जब हम लोगों ने ये याचिका दाखिल की थी 15 में,
हाँ।
क्योंकि जब एकदम ऐसा हो गया कि बिजली बिल काट ही देंगे और काटने वाले हैं, नोटिस दे रहे हैं, बहुत उन्होंने भी बहुत धैर्य बरता हम लोगों के साथ। 3 साल तक उन्होंने 12 दिन बंद कर दिया, 3 साल तक वैसे ही चले रहे, कोई पिटीशन नहीं। हाँ साहब, ये डिसाइड हो जाए अब आ रहा ही, और फिर उन्होंने कहा साहब काट ही देंगे बिजली फ्री।
नहीं वो ठीक है।
जी।
तो फैक्ट ये है कि पिटिशनर नंबर
सर, हमारा तो 1 इज कंसर्न, तो हम ये शुरुआती हम लोगों ने तो बिल वहां जब
12 से आपने रोका है
हमने
और 2 का भी वेरीफाई करना है उसको।
इनका सर थोड़ा रिप्लाई देख लें स्टेट का।
जी
ये 8/9/16 को जो इन्होंने किया, डॉक्यूमेंट नंबर 11059 ऑफ 16।
जी जी बताइए।
जैसा मैं कह रहा था सब, ये इन्होंने ये कहा कि जो हम लोगों ने 12 में अधिवक्ता पंचायत में बात कही थी, उस पर डेलिब्रेट किया और ये डिसाइड किया कि जहां पे place of sitting used by clients in the court premises will be examined so that government can pay the bills for the aforesaid premises. ये इनका पैरा 4 में है सर, पेज नंबर 3 पे। लेकिन सर पैरा 5 और 6 में थोड़ा सा ये डिविएट करके पढ़ते हैं।
पैरा 4 से पढ़ते हैं
जी, पैरा 4 से।
जी।
That as is clear from the facts mentioned above, my lord has it?
Yes.
The proceedings pending before the Honorable Supreme Court and special leave petition and the writ petition pending before this Honorable Court were disposed of pursuant to the announcement made by Honorable Chief Minister Adhivta Panchayat on 12/8/12. It is relevant here to mention that pursuant to the aforesaid announcement made in Adhivta Panchayat, the Department of Law and Legislative Affairs, Government of MP has called meeting on 8/10/12 of the Department of Law, Finance, General Administration Department and Revenue regarding the implementation of the announcement made by Honorable Chief Minister. It was resolved that the proposal regarding place of sitting used by clients in the court premises will be examined so that government can pay the bill for the aforesaid premises. It is also resolved that a report be called from all the three electricity companies regarding existence of electricity bill at the Tehsil and district level, and additional 10% increase in the budget allotment for the aforesaid expenses be made. The copy of meeting dated so and so is R1. That the Department of Law and Legislative Affairs has considered the claim of the different Bar Association of State of MP, wherein they have raised bill in relation to the office/hall maintained by Bar Association. And it was found that the Honorable Chief Minister has made announcement only for the payment of electricity bill of the premises place, which are being used by litigants/clients. And it do not include the building/premises used by the advocates in Bar Association for official purpose. And a recommendation was made that pursuant to the order passed by the Honorable Supreme Court in light of the announcement, the electricity bill of the place/premises used by litigants shall be reimbursed. It was also mentioned that an amount of rupees 65.59 lakhs is allotted for the aforesaid purpose. Copy of the order sheet in this regard is annexed R2. Now, important, my lord, para 6, that on 19/6/2013, the Department of Law and Legislative Affairs has issued the order indicating the amount sanctioned for different bar association at Tehsil and district level, and also the High Court Bar Association at Jabalpur, Indore and Gwalior. Copy of the amount section for 12 months is being filed herewith as annexure R3. That in the light of the aforesaid fact, it is submitted that the answering respondents, as per the announcement, has already made provision for payment of electricity bill, and its amount is sanctioned for Tehsil District Bar Association, so also the High Court Bar Associations at Jabalpur, Indore and Gwalior. And the same will be reimbursed to the Bar Association in accordance with the procedure prescribed. In view of the aforesaid, the answering respondents have already taken effective steps as per announcement made by the Honorable Chief Minister of the State of Madhya Pradesh. Now, this return probably at the later part, initially they were trying to distinguish, but from para 6 onwards, if we read this,
They have
kind of
literally conceded.
muddled whether it has to, assuming that it's a place which is exclusively for the purposes of people who come and sit.
They have given away that distinction.
Yes.
They said that they will be reimbursing the electricity charges to all the Tehsil District Bar Association, so also the High Court Bar Association at Jabalpur, Indore and Gwalior.
This is the return, my lord, which in fact has not been withdrawn. But subsequently, my lord, when we started relying on this, they filed some supplementary return saying that what they meant was only for those facilities, not ours.
कहाँ supplementary return?
ये दूसरा है सर.
27/16.
7 and 5.
डॉक्यूमेंट नंबर है सब उसका. ये after the rejoinder we filed, man, they came up. It was 6th April 17.
Document number 479.
4795 of 17.
4/5.
4795 of 2017. That's the document number. It was filed on
Additional return, yes.
Ji, additional return.
जी. क्या कहा इसमें?
इसमें सर पैरा 1 में तो कमोबेश वही बात थोड़ा रिलाई करते हैं. Different bar association, tehsil and district level. Before the Honorable has directed to place on record the information state government has made any specific and separate allotment relation to High Court Bar Association, Jabalpur, Indore and Gwalior. और ये आखिरी में कहने लगते हैं पैरा 4 में that the state government is not going to make any specific and separate allotment in relation to High Court Bar Association, Jabalpur, Indore, Gwalior, and the allotment is specifically related to sitting places of client in different forms. वहां नहीं बोलते ना ही उसको विड्रॉ करते. एक बार से एक और एडिशनल रिटर्न साहब इन्होंने दिया फिर 25/6/19 को दिया 8864 of 2019. इसमें पैरा 3 में देखेंगे सब पेज 2 में फिर से वही स्टैंड है कि जो हम लोगों वो जैसा स्टेट्स उसको समझ रही है तो क्या कुछ भी दिया हो इसमें जवाब में ये उसी जगह के लिए है
लिटिगेंट और क्लाइंट बैठता है
जहाँ सिर्फ क्लाइंट आके कुछ बैठ रहा है सुस्ता रहा है कुछ कर रहा है लेकिन वो अगर प्रेमिसेस एडवोकेट्स और बार एसोसिएशन अपने किसी काम के लिए यूज कर रही है तो उसके लिए नहीं ये ऐसा चेंज हो गया
स्टेट के लिए कौन है आप इतना पीछे क्यों बैठे हैं क्या Are you afraid of taking this case upfront?
No. He argued very eloquently and opposed us like anything.
नहीं. और पीछे बैठे हैं ना इसलिए पूछ लिया.
वो आगे सब कुछ और वर्मा जी से सभी को डर लगता है.
वर्मा जी से डरने की कहाँ बात है वर्मा जी बैठिए आप आराम से बैठिए डराओ मत भाई आपको भी इसी कोर्ट में प्रैक्टिस करना है डराओ मत गांगुली साहब डर गए तो आपके लिए दिक्कत खड़ी कर देंगे वो सरकार है हाँ गांगुली साहब, क्या स्टैंड क्या है आपका? 2+2 4 में बताइए, ये अलग अलग स्टैंड मत कीजिए। मैं आई एम गोइंग टू राइट अगेंस्ट योर ऑफिसर इंचार्ज हु हैज फाइल्ड द फर्स्ट रिटर्न।
सर मैं थोड़ा सा यदि हो गया हो तो मैं
आपका भी बचा है,
Just 5 minutes to submit.
कर लीजिए, उसके बाद बताइएगा। हाँ,
So, but in the light of the material that has come before my lords, the issue is very, very small. Although we have, my lord, have tried to deal it from all possible angles. The issue is whether the court annexed bar associations, which are part and parcel of the justice administration system, at the high courts or at the district or tehsil courts.
जी।
Now, I am restricting myself to the high court and that too, my lord, to the associations here in which
हाँ,
are petitioners.
ठीक,
my
ठीक।
lords. Whether we are entitled to free electricity from the state should provide the charges for the electricity to us or not. Now, very elaborately, my lord, in the division bench where the lordships have to arriving at a conclusion that those three premises, my lord, I pointed out in that orders.
Yes.
If my lord may come to the, I'll just those three findings that I say. Take. But their lordships have relied on the finding number 1, but page 15, it is clearly mentioned in the aforesaid that the lawyers are the officers of the court in the administration of justice.
उसको तो कोई डिनाइल ही नहीं है भाई।
Secondly, but just
आपके बगैर हम एक केस डिसाइड नहीं कर सकते। इसमें तो कहीं से कोई डिनाइल नहीं है।
mercy, Miller. It is clear from the aforesaid judgment in the legal profession has an effective and direct association with the administration of justice. Third is in the aforesaid, it is held that it's obligatory on the part of government to provide free electricity to the bar association. These are three premises that have come in.
Right.
In the light whereof, my lord, especially para 11, they said that you have to pay for the electricity. It's the state's obligation. State, yeah, so far as
पैरा 11 of
electricity-
विनोद कुमार।
Yeah, we know in reading. Para 11 and para 13, the lordships in Vinod Kumar's case, my lord, systematically lay down those 4 directions. Wherein the first direction is most important, said the electricity so and so, situated terrible, and now government is also liable to pay electricity charges, electricity appliance of notified bar rooms of the High Court, MP and Parliament. So so far as the legal aspect, whether who's entitled or not, my lord, my submission is that issue is no more res integra. The state is, my lord,
Liable to pay the.
liable to pay. Now, once having come to that, whether by whatever our understanding is at some point of a time, these associations paid some electricity charge, or so far as we are concerned, subject to verification from our parent body, whether they have ever paid or not. But the fact remains, well, so far as we are concerned, we are aware we had applied for a meter, we got a meter from 2008, probably when this premises came to us and we started operating there from 2006, the mini bar room was given, that still is connected to the High Court. There's no issue with regard, at least part of that facility, the first one that was granted to us, which now is in the allotted to the senior advocates council, that is connected with there's no separate meter there. It continues from day 1, my lord, as it has been allotted. So far as the other is concerned, my lord, we applied and got the meter paid for some time in 2012 in the light of the fact that we saw that our MP High Court Bar Association, in the light of the declaration of the Chief Minister and these decisions which have come up, my lord, we are not entitled, we stopped paying. After that, up till 2015, when we were pressurized that they are going to disconnect electricity, my lord, we came in this petition before my lords, and interim protective orders are in our favor ever since then, my lord. Although the respondent electricity board, my lord, keeps on raising from time to time electricity bills. And I am informed as of now, my lord, more than
मुकेश जी
30 odd
आपकी
lakh-
बार के मेंबर नहीं है क्या?
जी?
मुकेश जी आपकी बार के मेंबर नहीं है क्या? हैं? अच्छा, दोनों बार के हैं।
The beauty is as such, sir, कि-
ठीक है भाई।
They invited me to participate.
हम लोग दोनों के लिए पोजीशन है, but still
so it's better, all of us are some members somewhere or the other.
alternative, but we are defending our roles, my lord.
हाँ
right
ठीक है,
now.
ठीक है, ठीक है, ठीक है। अरे हमने तो पूछ लिया क्योंकि कह रहे हैं मुकेश जी करंट देते रहते हैं।
हाँ सब मेरा सर, मैं आपको एक मजेदार बात बताता हूँ जब तक कि जब ये अप्लाई किया गया सब, तो वो इंटरिम मैं सेक्रेटरी था, तो वो फॉर्म मुझसे भरा लिया गया सब, इसमें उसमें मेरा मोबाइल नंबर चला गया जो अभी तक वही।
अरे
तो मुझको उस पे सर पूरा आता है और वो कहा जाता है
तो इनमें भाई काजी साहब मनोज शर्मा जी को बाय नेम पार्टी बनाइए, क्योंकि अगर
सर ये प्रेसिडेंट का बिल, प्रेसिडेंट का मोबाइल नंबर देके रखे हैं, सेक्रेटरी का।
हम लोगों सबको बकायदा इतना बढ़ गया, इतना आ गया, 15 दिन में काट देंगे ऑफिस को, हर महीने
15
आता है।
दिन नहीं हुए थे प्रेसिडेंट बने और 40 लाख रुपए का बिल, मोबाइल पे मैसेज। बची रह गई।
इलेक्ट्रिसिटी ने भी देखा, जो वजनदार लोग हैं उनके नंबर रखे गए।
मुझे लगा मेरे घर का आ गया।
घर की
घर की
सबसे ज्यादा ऑफिस की।
The defaulter
क्योंकि अनफॉर्चुनेट पार्ट ऑफ दिस केस इज कि यदि रिकवरी हो गई, अलाउ हो गई, तो हम काय में कर लेंगे बिल्डिंग हाई कोर्ट की फर्नीचर
अरे अपोज बियनर से कर लेना, वो
नहीं,
तो है।
इलेक्ट्रिसिटी
हम लोग की
has noted the mobile number of the butler person.
चलिए ठीक है,
जी,
चलिए
जी।
ठीक।
So, मतलब once this
वर्मा जी, आप तो डिपॉजिट करा दो 50 लाख रुपए, अगर कहीं भाई एज ए सिक्योरिटी, और क्या है, सब्जेक्ट टू द फाइनल आउटकम ऑफ द पिटीशन।
So, sir, in these facts and circumstances, Bharadwaj, thereafter, my lord, what happened before the
BD
Honorable
Kaushik,
Supreme Court,
yes.
and BD Kaushik, which has been extensively relied on Bharadwaj itself, my lord, both the association, my humble submissions, my lord, are court and ex-bar associations. Both are duly recognized by the High Court, which is the requirement according to BD Kaushik. And we are part of the justice administration system, my lord, as held in Bharadwaj. So, in all propriety, my lord, the electricity board is supplying that power. It's doing it on business principle. It has to get the money. The
एक
only
चीज और
question
बता
is,
एक चीज और बता दीजिए, ये स्टेट को भी बताना पड़ेगा, somebody will have to pay, either the state pays or the will not leave the company.
naturally the company has to.
this is the somebody has to pay. स्टेट की क्या जवाबदारी होगी वो आप बताइएगा जब आपका आएगा। I'll not, somebody has to pay, either association pays or the government pays, but आप इस इशू को जब आप अरे मुझे मालूम है भाई, तो इसीलिए तो पूछ रहे हैं, somebody will have to pay, यही तो कह रहे हैं।
That's right. That's right. हम तो खुद ही कह रहे हैं साहब कि वो लोग बेचारे बिजली बना के दे रहे हैं, तो पैसा तो मिलना चाहिए।
सर, इसमें एडवोकेट जनरल साहब से रिक्वेस्ट करी थी कि ये बिल में आप कुछ मदद करिए। तो उन्होंने एक इनडायरेक्टली अनऑफिशियली बोला कि बिल सब बार एसोसिएशन का हम नहीं दे सकते, मतलब पूरे प्रदेश के, कोई ऐसा रास्ता निकालें कि ये हम हाई कोर्ट के हेड में देने लगेंगे बिल का पैसा, तो मैनेजेबल रहेगा। अदर
स्टेटमेंट दिलवा दीजिए ना, बुला लीजिए।
यही सर,
तभी में बोथ पार्टीज, ये तो बाद में आए, हमने तो वहाँ सेक्रेटरी साहब से भी बात कर ली, उन्होंने कहा सब हम किसी तरह हाई कोर्ट को दे देंगे। फिर हम लोगों ने हाई कोर्ट में ही बात करने की कोशिश की, आपको हेड क्रिएट कर
ऑफ रिकॉर्ड तो
नहीं, मैं आपको बता रहा हूँ बिकॉज़ संजय
नहीं ले सकते,
तो वो देने को तैयार थे, बट वो कह रहे हैं कि ऐसा पॉलिसी
अगर एडवोकेट जनरल अपीयर होकर स्टेटमेंट देते हैं तो मैटर विल बी पुट टू रेस्ट।
क्योंकि सर अल्टीमेटली देना तो है, और किसको देना है?
मैं आपसे यही तो कह रहा हूँ, इतनी सी बात है कि किसको देना है।
जी।
मुकेश जी का पैसा तो सेफ है।
हाँ, इसलिए उनको समझाते
नहीं सर, उनसे हम लोग ये कुछ रियायत की उम्मीद करेंगे कि जितना पैसा सर उससे ज्यादा उसमें ब्याज मिल गया है और पेनल्टी जुड़ गई है।
वो तो हम ही कर देंगे, उसके लिए आपको उनसे मिलने की जरूरत नहीं है। पेनल्टी तो हटा देंगे, वैसे लोक अदालत में रख के करवा देंगे। उसकी कोई दिक्कत नहीं है। इशू ये है हु विल पे, पूछ लीजिए आप, अगर आपके सरकार इंस्ट्रक्शंस देती है तो कोई रास्ता निकलता है तो ठीक है। आई एम नॉट आस्किंग यू टू फोरक्लोज योर आर्ग्यूमेंट्स, आर्ग्यूमेंट कर लीजिए, 5 तारीख को बता दीजिएगा, क्योंकि कंक्लूड तीनों केसेस 5 तारीख को ही होंगे। ठीक है, ऑर्डर्स तीनों के साथ में पास करूंगा। वर्मा जी अभी आप बैठे रहिए, अभी बैठे रहिए, जब बुलाएंगे तब आइएगा। नहीं, हाँ वो जो भी तारीख है, हाँ ठीक है। हाँ चलिए, अब आप बताइए आपका क्या स्टैंड है।
From the elaborated argument of my senior, from the elaborated argument, my lord, what is being gathered, my lord, that the petitioners are trying to canvass before your lordship, my lord, that still the order passed by the Gwalior division bench, my lord, is still intact, my lord, and on the basis of that judgment, my lord, now on the basis of the parity, my lord, the benefit should have been extended to what has been already held by the Gwalior bench, my lord. Now, my lord, in this regard, my lord, my submission is that after the order passed by the Honorable Supreme Court, my lord, my submission is that order has now got into merge with the order of the Supreme Court, my lord. And if there are some arguments, my lord, to that effect, my lord, that before the Supreme Court, my lord, the order of the Gwalior bench has not been detailedly described, my lord, then they could have an option before your lordships to argue a matter, my lord, wherein In a petition filed by a senior advocate, my lord, Mr. Rameshwar Nikra, this issue has again been raised.
जी
Now that order is annexed P3 to the writ petition, my lord, that may be seen, page 20.
जी
My lord, sir, page 20 of the writ petition,
Yes,
annexed
please.
P3.
जी
My lord, the order is of dated 30th-9/2014, page 21. My lord, in page 19, if page 20, my lord, if subject matter in brief is being seen, my lord, the similar grievance was there, my lord.
क्या पढ़िए
That in the present petition is being filed inter alia not against any particular order, but against the levy of electricity bill, which are which are paid by the respective bar association, whereas the same is required to be paid by state of Madhya Pradesh. That it so this is the crux, my lord, which has been mentioned there. So on 30th-9/2014, my lord, page 21, the PIL was disposed of, my lord, in the light of the order passed by the Honorable Supreme Court, my lord.
जी
So, my lord, now at this juncture, my lord, again raising a grievance that the state of Madhya Pradesh should have paid the retirement dues, my lord, in terms of the orders passed by the Honorable Gwalior bench, my lord. My submission is that they could have argued, my lord, this aspect before the
Division bench.
before the division bench, my lord. And once the division bench has earlier taken a view in page 21, then, my lord, again raising the grievance, my lord, before a division bench, my lord, again may not be a proper remedy, my lord.
जी
Now, my lord, my second argument is that that the entire argument is thrust upon the fact, my lord, that the Gwalior bench judgment is still intact.
एक
But-
सेकंड के लिए पहले ये बताइएगा कि ये पिटीशन किसने फाइल की थी
My lord, Mr.
रामेश्वर नीकरा ने
Nikra.
की थी इन व्हाट कैपेसिटी
My lord,
was
being
he was he a post bearer of High Court Bar Association or High Court Advocates Bar Association? Because once you raise this argument, then you are required to show that the petitioners who are before this court were arrayed as a party and that decision is binding on them.
no, my lord, they are not the party, my lord.
Then
Being a
if,
senior advocate,
if some Rameshwar Nikra files a petition in his individual capacity, then how can that bind High Court Advocates Association and High Court Advocates Bar Association?
but my lord, it can always be seen, my lord, that the order of the Honorable Supreme Court has been reiterated by
That
the
is different.
division
आपने
bench.
जब वो
हाँ,
आर्गुमेंट
हाँ,
किया हमने आपसे कुछ नहीं
जी,
कहा
जी, जी,
जब आप P3 पर लेकर आए तब हमने आपसे सवाल पूछा
जी,
है
जी, जी।
कि P3 से आप इनको कैसे बाइंड करेंगे
नहीं, इनका मेरा ये कहना है कि ये इशू दोबारा बार बार इसी पॉइंट पे रेज नहीं कर सकते और एक बार रिएटरेट ग्वालियर बेंच के बाद ये डिवीजन बेंच ऑलरेडी आ गया है। अब सर इनका कहना है कि ये जो ग्वालियर बेंच का ऑर्डर है ये अभी भी एग्जिस्ट करता है इन द आइज ऑफ लॉ, माय लॉर्ड, बट माय लॉर्ड मे काइंडली अप्रिशिएट द रिलीफ व्हिच हैज बीन प्रेड इन दिस पिटीशन, माय लॉर्ड। व्हाट रिलीफ हैज बीन प्रेड?
एक क्षण आते हैं ना जी रिलीफ बताइए
Now, my lord, the first relief is pertaining to respondent number 3 and 4. The relief number 3 is also pertaining to respondent number 3 and 4.
आपसे
Relief
क्या मांगा है
हमारा सिर्फ है 2 नंबर पे।
हाँ
डायरेक्ट द
आपका
रिस्पोंडेंट
पूरा काम 2 नंबर में ही है
जी
जी
हम 1 and 2 डायरेक्ट द रिस्पोंडेंट नंबर 1 and 2 to immediately make the payment of electricity bill of the bar association to respondent number 3 and 4 as per the statement made by the government of MP before the honorable supreme. So यदि इनका कहना है कि सुप्रीम कोर्ट का ऑर्डर में ग्वालियर बेंच का ऑर्डर यदि मर्ज नहीं हुआ है और वो ऑर्डर अभी इंडिपेंडेंटली एग्जिस्ट कर रहा है तो सर रिलीफ इस पॉइंट पे नहीं होनी चाहिए थी।
3 देख ले वो भी है।
बोलने दीजिए उनको फिर आपको चांस मिलेगा रिबटल का नोट करते जाइए जी
जी तो मेरा ये कहना कि सर they themselves are aware of the fact, my lord, that now the order of the honorable supreme court is binding on them, my lord. In these circumstances this specific relief has been claimed against the state government. So, my lord, now as your lordship has already pointed out that what is the order of the honorable supreme court, my lord? That order is page 18, my lord. I'll not repeat, my lord, but
Page-
the genesis of the
page
annexure
18
P1, my lord, page 18, my lord.
yes
Since my lords have already looked into that order, my lord, so
जी.
I will not repeat, my lord. But that order in specific terms has observed, my lord, that the proposal was sitting for the clients in the court compound public premises will be examined. This is the proposal, my lord. And in the same terms, my lord, the benefit have also been extended.
Where is the announcement made by your chief minister?
My lord,
ये
the
जो पंचायत था उसका कोई मेमोरेंडम तो बना होगा ना, जितने अनाउंसमेंट सीएम करते हैं या करते हैं उनका एक मेमोरेंडम बनता है टू बी फॉलोड अप. Whether you filed copy of that announcement
my lord,
and what was the exact tone and tenor of that announcement?
सर वो पेज हमारे रिप्लाई जो कि आईए नंबर डॉक्यूमेंट नंबर 11059/2016
11
11059/2016 जो कि
हाँ,
8/9/2016 को फाइल हुआ था.
उसका annexure क्या है?
इसमें अनेक्शर R1 पेज 9 है.
हाँ, ये तो मीटिंग है. हम आपसे जो सवाल पूछ रहे हैं तो आप समझ नहीं रहे या उसको अवॉइड कर रहे हैं.
नहीं सर, घोषणा को कोट किया पहले.
जो भी घोषणा की जाती है
जी
उसका एक मेमोरेंडम बनेगा.
जी.
सीएम जो भी घोषणा करेंगे, नहीं तो ऐसे तो घोषणाएं जो हैं वो दे विल बी लाइक पॉट होल्स ऑन अ रोड.
Yes, sir.
You will have to make a memorandum of those announcements and then they are to be given, they are to be implemented
Yeah.
because there is a promise extended by the executive head of the state to the people.
जी.
So where is that memorandum of that declaration?
सर वो मेमोरेंडम तो फाइल नहीं हुआ, लेकिन उसको वो डिक्लेरेशन फाइल हुआ जो कि सुप्रीम कोर्ट के सामने भी था.
हाँ
सर आप
बताइए.
सुप्रीम कोर्ट जजमेंट में भी देखिएगा सर, वो उसका नंबर आ रहा है
नंबर तो आ रहा है.
A2482
ठीक है,
और यही सर पेज नंबर 9 में आ रहा है, घोषणा क्रमांक 82482
एक सेकंड देखें, पेज नंबर 9 देखें क्या है.
9 में.
2842 पढ़िएगा.
जी. न्यायालय परिसर में पक्षकारों के बैठने के लिए स्थानों के बिजली बिलों की पूर्ति सरकार द्वारा किए जाने के प्रस्ताव का परीक्षण किया जाएगा.
जी.
सो ये बड़ा स्पेसिफिक था. अब सर इसकी कंप्लायंस में सर मेरा ये अनुरोध था सर आपसे कि आप अनेक्शर R1 एंड R2 जो हमने एडिशनल रिप्लाई के साथ फाइल किया था, इसको एग्जीक्यूट कैसे किया जाता सर, उसको भी थोड़ा सा देखो.
एडिशनल रिटर्न.
सर इसका नंबर है सर 4795/17.
एक सेकंड. हाँ, एडिशनल रिटर्न में क्या है?
सर इसका सर पेज 4 और पेज 5 देख लें. सर पेज 4 में सर एक लेटर का रेफरेंस है 3 जनवरी 13 का. इसमें थर्ड लाइन में है कि पत्रों के संदर्भ में समस्त अधीनस्थ न्यायालयों से उनकी न्यायिक स्थापनाओं में न्यायालय परिसर में पक्षकारों के बैठने के स्थान पर ट्यूबलाइट एवं पंखे लगाने हेतु विद्युत बिलों की आपूर्ति के लिए आवश्यक अतिरिक्त राशि का आवंटन की आवश्यकता संबंधी जानकारी संलग्न कर आपकी ओर प्रेषित किया गया. तो
जी.
ये हाईकोर्ट ये करके इकट्ठा करके हमको फॉरवर्ड करता है और वो फिर हम
उन्होंने
सब्सिक्वेंटली
एक और आर्गुमेंट किया है
जी.
कि डिस्ट्रिक्ट कोर्ट और तहसील कोर्ट में आप कहीं पर भी बिल नहीं ले रहे. इसके बारे में क्या कहना है?
सर जो पक्षकार बैठने की जगह है.
अरे भाई, आपसे जो पूछ रहे हैं उसका डिस्ट्रिक्ट कोर्ट बार एसोसिएशन में और तहसील बार एसोसिएशन में आप किसी से बिल नहीं ले रहे. इसके बारे में आपका क्या कहना है?
सर ये ओरल आर्गुमेंट है सर, ये रिटर्न में कहीं नहीं था तो हमने इसका जवाब भी नहीं दिया.
तो इसको ओरल आर्गुमेंट को नोट कर लेते हैं, इसका भी एफिडेविट दे दीजिएगा आप.
ठीक है.
Because this is one of the main, he is seeking parity. After arguing his own case on its own merit, he now, his second limb of argument is that even if the principle of parity is applied, then High Court Bar Association cannot be discriminated vis-a-vis District Bar Association or a Tehsil Bar Association, where state is not charging any amount for, होता है. जी. Note कर.
Privy to that.
नहीं. It will not be proper.
We can't say that.
That is on a lighter side. चलिए।
सर अब मेरा नेक्स्ट फैसेट ऑफ द आर्गुमेंट है कि सर ये विनोद कुमार
नहीं आप
भारत
इसको बता रहे थे, ये
जी।
एडिशनल रिटर्न के साथ में AR1 में क्या बता रहे हैं आप?
सर ये मैं कह रहा था कि ये हाई कोर्ट में सारी इन्फॉर्मेशन इकट्ठा होती है, फिर वहां से कम्युनिकेट होती है और उसके हिसाब से आगे के अलॉटमेंट्स होते हैं।
जी
तो द हाई कोर्ट इज नोइंग ऑल दीज फैक्ट्स।
जी।
अब सर विनोद कुमार भारद्वाज का सर जजमेंट एक बार और मैं आपको ट्रबल दूंगा सर आने के लिए।
नहीं
RJ1 है,
ट्रबल की कहाँ बात है भाई, उसको पढ़ेंगे ना।
पेज 12 सर। RJ1 पेज 12 से शुरू हो रहा था
कहाँ के RJ1?
सर,
रिजॉइंडर के साथ?
रिजॉइंडर के साथ जो लगा।
जी।
इसमें सर आपने 11 नंबर के पैराग्राफ में जो स्पेसिफिक ऑब्जर्वेशन आया था कि ये सिर्फ और सिर्फ ट्यूबलाइट
और तो
बल्ब
मालूम है,
और उसके
ट्यूबलाइट
लिए
बल्ब और कूलर,
कूलर के लिए
पंखे और
AC के लिए
कूलर।
नहीं है।
हाँ
सर इसका जो एक इम्पोर्टेंट पैरा जो मिस हुआ था सर,
हाँ।
वो था सर कंडीशन नंबर 13(3).
एक सेकंड, पैरा 11 में
पैरा 13 का 3 मिस हुआ था
13 का 3
पढ़ना।
पढ़ते हैं।
हाँ सर ये कहता है कि गवर्नमेंट कैन वेरीफाई द एक्सपेंसेस इन दिस रिगार्ड फ्रॉम द पब्लिक वर्क्स डिपार्टमेंट एंड शेल पे द सेम टू द हाई कोर्ट as an additional allotment so the high court can provide free electricity charges to the notified bars।
हाँ
तो सर यहाँ दो वर्ड्स इंपॉर्टेंट है ना, एक तो ये है कि इट विल बी अप्रूव्ड थ्रू हाई कोर्ट
जी
और नोटिफाइड बार।
जी।
तो सर यहाँ पर सर इन्होंने जो रिप्रेजेंटेशंस दिए हैं सर आप पिटिशन के साथ जो रिप्रेजेंटेशंस लगे हैं सर उसको देख लें सर। ये इशू कहीं भी टेकअप नहीं किया। यदि विनोद कुमार भारद्वाज कि जजमेंट की लाइट में यदि रिलीफ भी क्लेम कर रहे हैं
जी
तो सर इनके रिप्रेजेंटेशंस देखो
जी।
सर। अनेक्चर P4 पेज 23 से शुरू हो रहा है सर। पहला पेज 23 में ये है
P4
पूर्व क्षेत्र को दिया है। उसके बाद पेज 26 में है, ये भी एग्जीक्यूटिव इंजीनियर पूर्व क्षेत्र है। फिर P7 पेज 27 में भी पूर्व क्षेत्र है।
अरे तो जो मतलब का वो बताइए ना।
तो सर ये मेरा ये कहना है कि सर ये इशू इन्होंने कभी टेकअप भी नहीं किया और हाई कोर्ट को इन्होंने रिस्पोंडेंट भी अरे नहीं किया कि हाई कोर्ट भी अपना स्टैंड लेती ये कहते हुए कि साहब हम इसको दे सकते हैं, हमारे साथ से कैसा कनेक्शन की क्या व्यवस्था थी आज तक और अभी आगे चल के कैसे क्या हो सकता है।
रिप्रेजेंटेशन आज तक नहीं।
और ये इशू सर हम सिर्फ MPB के साथ ही टेकअप किया गया था।
स्टेट का कोई रिप्रेजेंटेशन नहीं आज तक।
जी
अब सर यदि रिलीफ नंबर 7 रोमन 2 ये कहती है कि
जी।
सुप्रीम कोर्ट में जो हमारा स्टेटमेंट था वो हम ऑनर नहीं कर रहे हैं, तो सर द रेमेडी इज नॉट अ रिट पिटिशन माय लॉर्ड, दे हैव टू
फाइल कंटेम्प्ट पिटीशन।
और सर यदि ये कह रहे हैं कि ये जो सुप्रीम कोर्ट में हमारी जो अंडरटेकिंग है उस अंडरटेकिंग के एम्बिट में इनका एसोसिएशन और वो रिक्वायरमेंट फुलफिल कर रहा है कि नहीं कर रहा है, ये भी स्पेसिफिक प्लीडिंग होनी चाहिए पड़ी।
एक सेकंड रुक जाइए। क्या कह रहे हैं आप?
सर मेरा ये आर्गुमेंट और लास्ट है कि सर यदि इनकी रिलीफ ये कि जो अंडरटेकिंग है उसको ऑनर हम नहीं कर रहे हैं, तो इनको एक पिटीशन में ये भी बताना था कि जो सुप्रीम कोर्ट में जो क्लाइंट्स के से कंसल्टेशन के लिए जो फैसिलिटी का एक्सटेंड हमारा कमिटमेंट था वो इनकी बार रूम में फैसिलिटी दी आ रही है और क्लाइंट्स से कंसल्टेशन हो रहा है। So whether they are falling under the ambit of the statement, my lord, they have to also demonstrate, my lord.
ये कहाँ लिखा है आपने अपने जवाब में? ये तो कल को आप रिगल आउट कर जाएंगे। ये जो आप बहस कर रहे हैं लास्ट पॉइंट, कि आपके जवाब में कहाँ है वो लाइन पढ़ के बताइए।
सर ये जवाब
आप
में
जवाब में नहीं तो ऐसी बहस मत करिए। कल को फिर स्टेट की बड़ी खास आदत है ये कि दूसरे कोर्ट में जाकर, सिंगल बेंच में तो डीबी में और डीबी में है तो सुप्रीम कोर्ट में जाकर वो बातें करते हैं जो कि कही नहीं जाती कभी। इसलिए इधर जब नोट्स लिखाऊंगा मैं तो लिखूंगा दैट दिस अवर्मेंट हैज बीन मेड बाय मिस्टर स्वप्निल गांगुली एज पर इंस्ट्रक्शंस। आप नाम बता दीजिएगा, उसका इंस्ट्रक्शंस लेके लिख नहीं, वो बहस मत करिए।
Last point that is not this stand.
Because
जी.
now I have learned at least this much that how government behaves and how government advocates argue their cases. अगर pleading नहीं है तो मैं एक चीज नहीं मानूंगा, और otherwise I'll bind you, I'll say that this is the argument made by Mr. Ganguly, though such pleadings are not available on record.
So these are my submissions.
Anything else?
No.
हाँ अग्रवाल जी बताइए, आपको अभी भी बहस करनी है क्या? कह तो दिया आपका पैसा मिल जाएगा, सरकार देगी, ये देंगे, वो बात की बात है। अब आप ये बता दीजिए इनको कि कितना कंसेशन देंगे आप, पेनल्टी, और आप भी तो सदस्य हैं बार के।
अभी तो प्रिंसिपल नहीं आया, अभी तो प्रिंसिपल का बिल मोर देन करोड़ है।
अरे वो ठीक है, अभी
नहीं वो
दिखा दें आपका ब्याज, आप ब्याज और पेनल्टी छोड़ देंगे।
नहीं लिखाएं तो हमारे गले में आ जाएगी।
तो बैठ जाइए फिर, चलिए ठीक है। एनीथिंग एल्स इन दिस पिटीशन, इलेक्ट्रिसिटी वाली? हाँ आपका क्या लोकस है, पहले ये बताइए।
Lucas, I am member of the bar. And whatever is going on,
आपने इंटरवेंशन एप्लीकेशन लगाई है क्या?
yes, my lord, my intervention application is another petition, my lord. And
In this petition,
yes,
I am asking
this
you,
petition-
in this very petition, WP 18637.
No, my lord. In the
नहीं है तो
last-
बैठ जाइए,
in the
नहीं है
last-
तो बैठे,
in the
नहीं है
last
बैठे।
dates, I am just to give, want
नहीं,
to bring the law before the lordship, my lord.
बैठ
Because the my submission is that electricity bill cannot be recovered from the bar.
आप तो वो लगाइए, इंटरवेंशन की एप्लीकेशन लगाइए, फिर सुनेंगे, नहीं तो इनको बता दीजिए जो आपको कहना है, मनोज जी को बता दीजिए, वो बता देंगे।
My lord,
I'll not
there is
hear
a
you.
judgment of.
No, I'll not hear you. I'll not hear you.
But I am giving judgment, my lord.
हाँ तो उनको दीजिए ना, you are free to
Because-
give him.
Because the
I'll
question-
not hear you, Mr. Counsel. Thing is very clear. If there is an intervention application by you as a member, I'll hear you. If
Lord,
there
the
is
last dates, my lord.
no,
My lord,
sorry.
my lord. And the last
Last date, if some mistake has been committed, I'll not
mistake.
perpetuate that
Not
mistake.
mistake. It a liberty
नहीं,
is
what
given by
day
the
is-
lordship, my lord, that if
I
a
have not
member
given
want
you-
to put his submission for
I have
interest,
liberty.
for
Order
larger interest, my lord,
बताइए,
he put submission.
order sheet बताइए, कौन सी order sheet है?
My lord, on the last date, my lord, the
Order sheet बताइए वकील साहब,
my lord,
किस order sheet
it
में
is-
लिखा है?
But it is a discretion of the
No,
lordship.
no, sorry. I refuse to exercise that discretion. Whatever you want to say,
if it-
say it through Mr. Manoj Sharma or Mr. Swapnil Ganguly or Mr. Mukesh Agrawal. Whosoever is the interested party in your estimation, I'll not hear you. हाँ दे दीजिए।
Your lordship, I have filed intervention application in.
हाँ आपकी इंटरवेंशन अलाउ हो गई क्या?
No, your lordship.
हाँ तो इंटरवेंशन एप्लीकेशन आइए नंबर।
Your lordship. It is your lordship 173802/23, your lordship.
हाँ बताइएगा।
17/3/23 को फाइल हुआ है
हाँ
सर।
बताइए 17/8।
इसमें हम इंटरेस्टेड पार्टी ऐसे हैं कि because we have filed a petition, basically we are challenging any facility, free facility to petitioner number 1, your lordship.
वो तो उस पिटीशन के आउटकम के ऊपर डिपेंड करेगा।
Your lordship.
If he uphold your submission that their association is not to be recognized, then things will be dependent on that. If
Your
we
lordship.
say that if we dismiss your petition, then things will be different. तो आज तो आपका कोई लोकस नहीं है, आप भी बैठ को
Sir,
जब वो
we
बहस
also-
बिजली में नहीं सुनेंगे, प्रेमाइसिस के लिए, एसोसिएशन के रिकॉग्निशन के लिए आपको सुनेंगे। हमने आपसे कल भी रिक्वेस्ट किया
जी
था
सर।
कि जब एक बार आर्गुमेंट कंप्लीट हो जाएंगे, आई विल गिव यू एन अपॉर्चुनिटी टू रिबट आर्गुमेंट्स मेड बाय द अदर साइड, दैट आई विल ग्रांट यू एंड
Your lordship.
वी विल अबाइड बाय दैट। ठीक है चलिए हम ओके। मनोज जी क्या बताना है, ये क्या देगा आपको इतनी इंपॉर्टेंट पुड़िया?
तो कुछ डिसीजन है, मैं थोड़ा देख के आपको सबमिट करना चाहूंगा, मैंने पढ़ा तो है नहीं अभी।
वह? क्या डिसीजन है वो?
पंजाब हरियाणा का है सर, पंजाब हरियाणा हाई कोर्ट का कुछ बता रहे हैं।
आपके हितैषी हैं और आपको जजमेंट भी टाइम से नहीं दिया इन्होंने।
वो शायद स्वयं भी बताना चाह रहे होंगे।
लाइए दीजिए, हम देख लेंगे। लाइए
जी।
दीजिए।
तो और कॉपी दे।
लाओ दे दो भाई रीडर साहब। ठीक।
Sir, my application for vacating interim order is also pending in this petition, your lordship.
अरे पहले जब तक आपका इंटरवेंशन अलाउ नहीं होगा वर्मा जी,
Sir,
तब
actually,
तक आप कैसे हो
your
जाएगा?
lordship, this honorable court has already been treated to be intervener in the earlier orders as per.
कहाँ है वो बताइए, ऑर्डर शीट बताइएगा।
Sir, क्योंकि मेरे
कब आपकी
क्या
आपकी इंटरवेंशन कब अलाउ हुई बताइए तो प्लीज।
सर, वो उन्होंने स्पेसिफिक ऑर्डर नहीं किया, पर मुझे एज ए इंटरवीनर उन्होंने ट्रीट करते हुए हर ऑर्डर में लिखा है सर।
लिखा होगा लेकिन मैं तो स्पेसिफिक ऑर्डर के बगैर नहीं कर पाऊंगा।
मैं फैक्ट बता रहा हूं सर।
आपके फैक्ट समझ गए हम।
So,
आपका जो टोटल डिस्प्यूट है वो पिटीशन नंबर 1 के साथ है।
मैक्सिमम तो है ही सर।
हाँ ठीक है ना, वो कल आपने बता दिया, वो समझ लिया हमने।
नहीं सर, पर बिजली कंपनी के खिलाफ, बिजली काटने के खिलाफ रेमेडी 226 में नहीं है, इसके लिए कई जजमेंट्स हैं। और पीआईएल जो है इन द शेप ऑफ
वो
डब्ल्यू
तो इलेक्ट्रिसिटी बोर्ड बताइए, मुकेश जी को बताइए, वो बताएंगे, उनको
नहीं,
असिस्ट
सर,
करिए।
बिकॉज़ इट्स पब्लिक मनी इन्वॉल्व, दैट्स व्हाई
हाँ ठीक है, उनको असिस्ट करिए, वो बताएंगे।
नहीं सर, अगर उनको इंटरेस्ट होता किसी भी सरकारी कंपनी को, 2016 का ये पेंडिंग है सर उनका, और अभी हम 24 में बहस कर रहे हैं सर। 8 साल हो गए सर उस स्टे को।
Public money when we are involved, public money when our parented institution is not public, because he is not opposed to that.
सर मेरा भी उससे
इसीलिए तो इनको रोक रहा हूँ मैं, क्योंकि there is an inherent contradiction.
सर उसमें भी मेरा एक कहना ये है सर कि अगर स्टेट ने एक बजट दिया है कि 1 करोड़ हम पूरे स्टेट को देते हैं, एक प्रिजम्पशन मान लूं मैं, तो उसमें से मान लो इन्होंने 90 लाख खर्च कर लिए अकेले, और टोटल बिल 1.5 करोड़ है, तो 60 लाख कौन देगा फिर? उन्होंने अलग अलग देने को नहीं बोला है किसी को। शासन ने कहा है कि हमारा एक कोटा है स्टेट को देने का, और हम एक इतना बजट देते हैं। पर आप अगर 3-4 बॉडी बना लो, या भारद्वाज के केस में ये कवर नहीं होते सर, पिटिशनर नंबर 1। और जो बीडी कौशिक में कोर्ट एनेक्स बाहर से हमारा
आप
इंटरप्रिटेशन।
संजय वर्मा जी से इंस्ट्रक्शंस ले लीजिए, दोनों पिटीशन अलग अलग कर देते हैं, पिटीशन नंबर 1 की अलग और पिटीशन नंबर 2 की अलग।
सर ये लोग, इनका क्या रहता है, ये बॉडी के जो ऑफिस बेयरर्स होते हैं
देखिए, एलिगेशंस मत लगाइए
सर, मैं किसी का नाम नहीं लूंगा सर।
नहीं, नाम नहीं,
पर इनका क्या है कि ये टाइम एक बार यहाँ चुनाव लड़ते हैं, एक बार वहां, तो दोनों जगह बैलेंस बना के रखते हैं सर।
ये मैडम प्लीज बैठ जाइए, मैडम आप बैठ जाइए, आपका कोई लोकस नहीं है। Mr. When senior counsel is standing, he will reply whatever is required.
सर मैं ये कह
देखिए,
रहा
ये सब नहीं सुनेंगे, आपका इंटरवेंशन अलाउ नहीं हुआ है। आपकी पहली पिटीशन में आप पिटीशनर हैं, उसमें आपको एट लेंथ सुन चुके हैं, और भी जरूरत पड़ेगी तो सुनेंगे आपको। यू विल हैव अ राइट टू रिबट व्हाटएवर इज सेड बाय एनी ऑफ द पार्टीज। ठीक है, चलिए।
पर ये एक पॉइंट आया है सर जो मेरा कहने का, फिलहाल इसको सुन ले सर। अभी आप इसको अभी ये मत सुने, पर मान लीजिए कि सरकार बिजली दे देती है किसी भी तरीके से,
हम हाइपोथेसिस पे नहीं जाते।
पर वो एक कहेंगे कि अलग अलग बिजली नहीं देते सर वो किसी को।
ठीक है, चलिए, बुलाओ स्टेनो को, बुलाओ।
मैं सिर्फ हमारे रिजॉइंडर से 2 पैराग्राफ्स पर
जी,
वो जो एक बात थी कि हम ये कह रहे थे कि बाकी डिस्ट्रिक्ट वालों को भी जो दे रहे, वो हमारा पार्ट ऑफ प्लीडिंग।
ठीक है, तो हमने उस पर डिस्प्यूट कहाँ किया? हम तो उससे सवाल पूछ रहे हैं, लिखिएगा उसको। हमने कहा
7 में सर, दैट वेरी सरप्राइजिंग
ठीक है,
स्टेटमेंट।
आई हैव नॉट डिस्प्यूटेड दैट, लिखिएगा।
It has my
Manoj
basis
Sharma,
in my
learned senior advocate with Shri Kaji Fakhruddin. Shri Swapnil Ganguly, learned deputy advocate general for the state. Shri Mukesh Kumar Agrawal for the electricity company. Next, this writ petition, ye WP 18637 of 2016. This writ petition is filed mainly on the premise that the bar associations, namely High Court Advocates Bar Association within Jabalpur within bracket petitioner number 1 and Madhya Pradesh High Court Bar Association Jabalpur, petitioner number 2 are not liable to pay electricity bills, full stop. Placing reliance on the judgment of division bench of this High Court at Gwalior in Vinod Kumar Bhardwaj versus State of MP and others 2013 का एक MPLJ 597, it is submitted that division bench of this High Court at Gwalior has already held that bar associations are integral part of justice dispensation system, and therefore electricity bills to the extent of meeting expenses for bulb, tube light and fan and water coolers during the summer season are to be provided by the state. Full stop. Reading this judgment exhaustively, it is submitted that petitioner is seeking parity with the judgment in case of Vinod Kumar Bhardwaj. Next paragraph. Reading from the judgment of Supreme Court in case of Supreme Court Bar Association and others versus BD Kaushik 2011 का 13 SCC 774, specifically para number 27, 28 and 80, it is submitted that Supreme Court Bar Association, as the name suggests, is a society meant to promote the welfare of the advocates generally practicing in the Supreme Court. Full stop. It is submitted that the formation of SCBA is held by the Supreme Court to be in the nature of aid to the Advocates Act 1961 and other relevant statutes, including Article 145 of the Constitution. Full stop. Next para. Reading from para 28 of the said judgment, it is submitted that Supreme Court has held that court-annexed bar associations constitute a separate class different from other lawyers associations such as Lawyers Forum, All India Advocates Association, etc., as they are always recognized by the court concerned. Next para. It is further held that court-annexed bar associations function as part of the machinery for administration of justice, and thus it is pointed out by the learned senior counsel that even Supreme Court extends several facilities including payment of electricity bills for the functioning of the Bar Association SCBA and the lounges, etc., which has been provided by lounges, libraries, canteens, etc., which have been provided for the facility of the advocates. Next paragraph. It is submitted that petitioner number 2 was neither charged nor paid any electricity bill since its inception when the High Court was shifted from Nagpur to Madhya Pradesh on 1st November 1956. But petitioner number 1, since its inception and on being allotted the current premises adjacent to the courtroom number 9 नहीं आएगा क्या कर
In front of the copying section of a
in
copying
front of
section.
the erstwhile copying section.
Erstwhile
copying section had obtained an independent electricity connection and continued to pay its bills regularly. But in the year 2012, in a Adhivakta Panchayat, the then Chief Minister of the state had made a public announcement, and thereafter they have stopped paying the electricity bills. Full stop. Their main contention is that the state has filed 3 returns. In the first return, they have initially agreed that it is the High Court which has to pay the bills. Then it is submitted that in the second return, they have taken a diametrically opposite stand and has stated that as per the announcement made in Adhivakta Panchayat, state is liable to bond expenses for electricity, etc. only for the places which are meant for the clients. Full stop. It is submitted that this stand is contrary to the decision rendered by Division Bench of this High Court in Vinod Kumar Bhardwaj, Supra. Next pair. It is also submitted by Shri Manoj Kumar Sharma that in district court bar associations and Tehsil court bar associations, all the electricity charges are being borne out of the budgetary allocation made for district judiciary. But in the case of High Court, they are being treated differently, which amounts to discrimination. Next pair. Shri Swapnil Ganguly, Learned Counsel for the State, submits that judgment of Gwalior bench has merged with that of the Supreme Court as is enclosed by the petitioners themselves as Annexure P1, that is the order dated 28/4/2014 passed in petition within bracket S bracket close for special leave to appeal within bracket civil bracket close NO bracket में S bracket close dot 14402 of 2013, and therefore if petitioners are alleging any non-compliance of the said order, then their remedy is by way of filing contempt petition before the Supreme Court and not in filing a fresh writ petition before the High Court. Next pass. It is further submitted that similar issue was raised by one Shri Rameshwar Nikra by filing WP number 2165/2013 within bracket PIL, and Division Bench of this High Court wide order dated 30/9/2014 dispose of the petition in terms of the observations made by the Supreme Court on 28/4/2014 in SLP civil numbers 14402/13. Next para. Number 14402/2013. ठीक है? Next para. Shri Ganguly further submits that the only relief which has been sought against the state is that the state should reimburse the expenses. There is a tacit admission in regard to the decision of the Supreme Court dated 28/4/2014, which is binding on the parties. Full stop. It is further submitted that declaration which was made by the Chief Minister, gist of which is enclosed along with the annexure R1 with return filed wide IA number 11059/16, and that reveals that the declaration was made in the Adhivakta Parishad in regard to places meant for the litigants and not for the lawyers. Next pair. Shri Ganguly further submits that petitioners have not arrayed High Court as a party. Full stop. It is further submitted that in para 13 within bracket 3 of the judgment rendered in case of Vinod Kumar Bhardwaj, two things are apparent. First, even if a state is made to pay, then a state is liable to pay only towards the electricity expenses which are to be borne for running a fan oblique electricity bulb oblique, fan and fan, bulb oblique tube light and water coolers during summer vacation or during summers. It will not include expenses for running commercial equipment like photocopy machine, etc., or air conditioners, etc. Full stop. Shri Mukesh Agrawal in his turn submits that as far as electricity companies are concerned, they are only interested in realizing their dues because they, being a commercial entity, they have to purchase power or have to incur expenses on production of the electricity, and they cannot be benevolent towards the bar association or anybody else by not claiming their dues. Full stop. He submits that be it the state or the bar association, as the case may be, their dues be cleared at the earliest. Next paragraph. At this stage, Shri Manoj Sharma has drawn attention of this court towards the judgment of Punjab and Haryana High Court in Punjab and Haryana High Court Bar Association versus Union of India and others, decided on 30 May 2007, reported in 2007 का 147 PLR 565, and submits that even in Punjab, electricity charges are borne by the Union Territory Administration. Next para. Shri Ganguly is Learned Deputy Advocate General is directed to seek instructions on a plea of discrimination being raised by Shri Manoj Sharma that District Court Bar Associations and Tehsil Bar Associations are being provided electricity by the state authorities or out of the budget of the court administration, whereas High Court Advocates Bar Association and High Court Bar Association are being discriminated in this regard. Let affidavit of the Principal Secretary of the Law and Justice Department be filed in this behalf on or before next date. In the meanwhile, Shri B.N. Mishra कहाँ गए? बता दीजिएगा उनको. Is directed to seek instructions from the Registrar General of the High Court in this behalf.
Registrar
And-
General has also intimated, I have submitted his letter with my return.
हाँ,
Okay, he has no role in this case, Lordship.
वो तो मालूम पड़ेगा जब धीरे धीरे केस आगे बढ़ेगा कितना रोल है. फिल्म तो हमें बनानी है ना. आप उसमें एक्टर हैं. राव साहब आप तो नहीं है पीछे, कम से कम आप अपने खुद के मुकदमे में नहीं आते. बैठिए. क्या हुआ? रजिस्ट्रार जनरल इन दिस बिहाफ. ठीक है ना. लिस्ट दिस केस ऑन 6th February 2024 along with वो पहली वाली WP का नंबर ले लीजिएगा. चलिए अब तीसरा केस.
तो 6 को स्टार्ट कर सर.
अरे नहीं 6 को कौन
ठीक.
वेट करेगा.
ठीक कर दे.